Imagine dedicating years to developing a groundbreaking artificial intelligence system. Its core strength lies in its unique algorithms and the vast, curated datasets it learns from. How do you ensure this invaluable intellectual property, this secret sauce, stays secure when collaborating with others? Protecting artificial intelligence proprietary data primarily relies on robust contractual frameworks. The most essential tools include non-disclosure agreements, carefully crafted intellectual property assignment clauses, and comprehensive licensing agreements. These legal documents establish clear boundaries and obligations. At their heart, these contracts function by legally binding parties to uphold specific duties regarding confidential information. Non-disclosure agreements, commonly known as NDAs, create a confidential relationship where recipients agree not to disclose or use proprietary data for unauthorized purposes. Intellectual property assignment clauses explicitly transfer ownership of any new developments or derived works back to the original owner, preventing unintended rights acquisition. Licensing agreements, on the other hand, define the precise terms under which another party can access, use, or modify the artificial intelligence system or its data, specifying scope, duration, and restrictions. These agreements are crucial because artificial intelligence data often qualifies as a trade secret, a form of intellectual property protected by its secrecy and economic value. To effectively leverage these protections, it is vital to ensure that your contracts include several key elements. First, precisely define what constitutes proprietary data within the context of your artificial intelligence system, including algorithms, training datasets, and model parameters. Second, establish clear limitations on access and use, specifying who can access the data, how it can be used, and any prohibitions on reverse engineering or competing development. Third, incorporate strong data security clauses requiring the implementation of reasonable safeguards to prevent unauthorized access or breaches. Finally, always include provisions for the return or destruction of data upon termination of the agreement, along with detailed remedies for breach. Beyond these foundational elements, consider integrating specific clauses tailored to artificial intelligence. For instance, a restricted use clause can strictly limit how training data is employed, preventing its use for competing models or broad commercial purposes outside the agreement's scope. Source code escrow arrangements provide a neutral third-party hold of the artificial intelligence system's source code, ensuring access under predefined conditions, such as the dissolution of a vendor. Furthermore, establishing explicit data ownership and usage rights for any derived or refined data generated during collaboration is paramount, addressing the unique challenges of machine learning, where new insights are constantly being created from existing data. By proactively implementing these layered contractual protections, organizations can safeguard their artificial intelligence proprietary data, mitigate the significant risks of unauthorized use or disclosure, and foster a secure environment for innovation. This meticulous legal groundwork ensures that the valuable intellectual assets driving modern artificial intelligence development remains firmly within the control of their creators, supporting sustained growth and competitive advantage.